the second panel this morning, human rights and international crimes. We will have 3 speakers and then some time for questions and discussion at the end. So if we want to start with Margareta Wewerinke from the University of the South Pacific, talking about the right to enjoy culture in the face of climate change, implications for climate refugees.
Thank you very much, and of course thanks to the organisers for this brilliant conference and opportunity to learn from each other and exchange views. My name is Margareta Wewerinke. I'm a lecturer at the University of the South Pacific, the law school, which is based in Vanuatu and Port Vila. The University of the South Pacific is a university, and it's also a intergovernmental organisation with 12 member countries that are all Pacific Island states, or countries, I should say. Most have statehood, but not all of them. So what I'm going to talk about today is climate-induced migration from a human rights perspective, and addressing this issue through the lens of a specific human right, which is the right to culture. So to start with, I'll give you some illustrations of the impacts of climate change on the enjoyment of human rights from the South Pacific region, and then looking specifically at how climate change affects the enjoyment of the right to culture. And I'll look at the right to culture in conjunction with the right to self-determination. That is because the jurisprudence of the Human Rights Committee, which is the treaty body mandated to interpret and monitor compliance with the International Covenant on Civil and Political Rights, which protects the right to culture. The right to culture and the right to self-determination are linked. So very often you see when the Human Rights Committee interprets Article 27 of the ICCPR, which protects the right to culture, it also looks at Article 1 and how Article 1 affects the scope and other features of the right to culture. So I'll be doing that as well, looking at the various aspects of the right. And then finally, I'll provide some ideas about opportunities for the cross-fertilization of regimes, mainly the climate change regime and the human rights regime, looking at the UNFCCC developments on loss and damage that we have already heard about this morning, and the role of human rights bodies. So as we all know, we are now at about 1 degree of warming, and we're heading towards much more. If the pledges submitted under the UNFCCC would be fully implemented, we'd have probably about 3 degrees of warming. These illustrations show what between 0.8 and 1 degree of warming means for Pacific Island states. So this picture is from the Republic of the Marshall Islands, the capital Majuro, where this kind of flooding is now happening on a yearly basis. Here's some children playing in king tides flooding in Kiribati, and you see that people are trying to adapt by putting their houses on stilts. Flooding in the capital of Tuvalu. Similarly, people are trying to elevate their homes, but still the impacts of the flooding are significant because many food sources are destroyed. And of course, sea level is what is most discussed when it comes to the impact of climate change in the Pacific. But apart from changing weather patterns, we also see increasingly severe natural or climate-induced disasters happening. This picture is from Tonga. Cyclone Ian hits the most vulnerable islands of Tonga, the Hapai Islands, in 2014, destroying much of the infrastructure and housing, food sources and so on, that were there. Last year in Vanuatu, Category 5 Cyclone Pen hit many of the islands, causing immense destruction economically. About 67% of the GDP or the costs amounted to about 67% of the GDP of Vanuatu, and many food sources were also destroyed. And this was followed by a very severe drought, triggered by an immensely strong El Nino, unprecedented, again causing a loss of livelihoods and even human lives. And same is true for Fiji, where this year, another Category 5 cyclone, again of unprecedented strength, caused immense destruction. About 50 people lost their lives. Damage amounted to about $1 billion Fijian dollar. And of course, what all these events together trigger are questions about the sustainability of life on these islands. So now looking at the law, the right to enjoy a culture is a right that is protected under the ICCPR, as I mentioned. This is the text of the provision, which protects the right, and then together we look at this right in conjunction with Article 1 of the ICCPR, which is, as you know, identical to Article 1 of the International Covenant on Economic, Social and Cultural Rights, which protects the right of self-determination, and also clearly states that in no case may a people be deprived of its own means of subsistence. So who are the beneficiaries of this right? As was already pointed out this morning, when you use a human rights perspective, you start looking at the people who enjoy the rights usually when analyzing the situation. So here the beneficiaries of the right to culture are persons belonging to ethnic, religious or linguistic minorities, so individuals. And it's very clear from the jurisprudence of the Human Rights Committee that members of indigenous peoples will usually qualify as members belonging to minority. Of course, there is a requirement of being a minority, so of numerical inferiority. So that means that you can't automatically say that the population of Tonga or Vanuatu, for example, enjoys the right to culture as such as a population, because they're not a minority as such. They would be, perhaps, in some cases, a people. But when you look more closely at the cultures of these island countries, you can actually see such diversity that perhaps you can identify many different minorities within those populations. And it's very clear if you look at Vanuatu, for example, there are 65 inhabited islands, and there are 110 different languages. It's the most linguistically diverse country on earth. Each island also has its own musical traditions, dancing traditions, and it's not just true for Vanuatu. And here we see a string band from the island of Tanna. Perhaps some of you have seen the movie, Tanna movie. This is one of the communities that live on the island of Tanna. It's also true for Fiji and most of the other Pacific islands. Here you see some traditional dancing going on one of the islands in Fiji. And those dancing and musical traditions and so on, they're not just performed for entertainment, but they fulfill important social functions. For example, perhaps surprisingly, but many songs actually relate to navigation. So from the perspective of small island states, we shouldn't actually be talking about small island states, but rather about big ocean states. But people who live there have been navigating the seas for many, many centuries. And so here we see a traditional canoe building family, building canoes in Tuvalu. And that has been done for many generations by this particular family. And then often others, again, are specialized in navigation. Here we see some young men from the federal state of Micronesia navigating the seas, using their knowledge of the seas, of clouds, looking at the clouds, at the night skies and so on, to navigate, to determine where they are and where they can go. And then often islands have their own songs to tell people how to get away from the island or how to how to get there, and so on. So all these elements of culture really are intertwined with a particular way of life that is actually quite sustainable as it is. It's clear that most of the people that we've just seen who are really at the forefront of climate change are beneficiaries of this right to culture. So what are states' obligations to protect this right? So again, looking at the jurisprudence of the Human Rights Committee, what is interesting is that the Human Rights Committee really starts looking at the enjoyment of the right to determine whether or not it has been violated. So it says explicitly here in this case, Mahauka versus New Zealand, that the scope of the state's freedom to encourage development or allow economic activities is not to be addressed by reference to a margin of appreciation, but rather by reference to the obligations the state has undertaken. And then it quotes the article again, and then saying measures whose impacts amount to denial of the right will not be compatible with the obligations under Article 27. Then of course that triggers the question, what is denial of the right? When is the right actually denied? Again, it's looking at the jurisprudence of the committee. It's seen what they are saying. It's still a little bit vague, but what they are saying is if there is an interference that is substantive, then that could amount to a violation. And when is it substantive? That is when an indigenous economy is no longer sustainable. So then, looking at the question of sustainability of the local economy, here just an illustration here from Kiribati. Of course, coconut trees are a very important source of food and revenue in the Pacific Island states. Here you see that coconut trees are dying as a result of coastal erosion, and people are becoming dependent on food imports, which are often subsidized by aid or paid for by aid, and that is not very sustainable. And this has caused the first people to actually migrate, leave their traditional lands, because there was no food available anymore. Here you see one of the first initiators of climate-induced migration from the Carteret Islands in Papua New Guinea. People have actually left those islands and went to live still within PNG, but in mainland and Bougainville, near the capital. The jurisprudence of the Human Rights Committee also clearly articulates a participation requirement. So the state must not just ensure that the traditional economy can continue to exist in a sustainable way, but also must involve affected communities in participations or in decisions that affect them. And here another very important point is that these obligations are not territorially confined. They are the obligations of states depend on the amount of control that they have over a situation that actually or potentially interferes with those rights. That means that we are not just looking faithfully at obligations of the states that are of governments of the countries that are affected, because often the means of those countries for preventing the violation are very limited. We're also looking at the states with control over actors or activities that cause climate change, right? And this enables us to inject a climate justice element, if you will, in discussions through human rights, which are legally binding or the existing law, right? And then also states with capacity to prevent violations through finance, capacity building, technology transfer, and so on. And also, of course, the potential host states of climate migrants. There's no, it really seems that the obligations we're talking about do extend to those states. What that means in practice remains unclear. Of course, there's very limited jurisprudence on specifically the obligations of those states in the context of climate-induced migrations. And a related question here is, to what extent are these rights already being violated? For example, if we look at this, the migration of the Carteret Islanders, they didn't choose to leave. They were forced to leave because their food sources had been destroyed in a way. and this is, at least in fact, in part attributable to the actions of states that have caused climate change. To what extent can you actually frame this legally as a violation? That's a question. It's an important question, because the answer to that could inform responses. Because when you can actually establish a violation, as we heard this morning in Jenny's and Yolanda's presentations, there's the law of state responsibility and also international human rights law, which provides that those states have responsibilities or obligations to make reparations, and victims have a right to remedy. So what would be appropriate remedies is then another implied question. And then, of course, when we talk about the right to culture, there is the question about how to reconcile this principled human rights-based approach with the dynamic nature of culture. Then, because, of course, migration is inherent in many cultures. When can you speak of a violation, and when are people still exercising their right to culture? Then opportunities for cross-fertilization of regimes. It's clear that we need more clarity about states' obligations, and we need better implementation of existing norms if we accept that indeed the people we're talking about are beneficiaries of rights and are legally covered by these norms. One option, much discussed, is the possibility of creating new instruments or mechanisms that take a more holistic or integrated approach to issues and regimes. That could be under as part of refugee law, or under the UNFCCC, or it could be Human Rights Convention. But I think we would probably all agree that a new instrument would need to draw on existing laws from the different regimes. Then there are the developments in the UNFCCC, including the COP21 decision, where parties decide to establish a task force on climate-induced migration or displacement. And the text there also says explicitly that parties, or that the task force should involve and draw upon the work of bodies outside the convention, which could include human rights experts, right, including OHCHR, the Office of the High Commission for Human Rights, Human Rights Council, Special Procedure Mandate holders, treaty bodies, regional mechanisms, academics, NGOs, and so forth. And then, from a human rights perspective, it's interesting to note that there's ongoing work of almost all human rights bodies now on climate change and human rights. So, for example, the Human Rights Council just last week, Friday, adopted its 6th resolution on human rights and climate change. And it seems that the Human Rights Council is now creating a trend of focusing on a thematic issue every year. Last year it was health. Now it's going to be children's rights. Next time it could be climate-induced migration, for example. You could draw in experts from the different agencies, expert bodies, and so on in those discussions. And then, of course, the Human Rights Council can make decisions and create new mandates. If necessary, you could start work on a new treaty. You could do many different things. And then, of course, when it comes to integration, there's much work to do also within countries, and that's especially true probably for developing countries, in making sure that they draw on the expertise in between different ministries, negotiators, and so on, so that everyone who follows the Human Rights Council is also aware of what is happening on loss and damage and climate-induced migration in the UNFCCC and so forth. And then finally, of course, when it comes to integration, climate litigation also offers a lot of possibilities, because a judge or an expert in a human rights body could be presented with legal arguments that draw on different sources of law, and then new interpretations could arrive that are more holistic and integrated. So far, just to really make use of the opportunity of being here with so many people from who are really engaged in these cutting-edge discussions. I thought I should put up a picture of my students here. In the spirit of the participation requirement, these are very talented young lawyers from the South Pacific who should be engaged in these discussions. So if you know of, let's say, scholarships, PhD scholarships, or paid internships, or other opportunities for them to engage, please make sure that your call reaches them. Thank you.
Sumudu Atapattu from the University of Wisconsin, who's going to be talking about a new category of refugees, climate refugees and a gaping hole in international law.
So thank you again to the organizers for inviting me, and as you pointed out, really looking forward to the discussion and learning from everybody else. The presentation comes from my book, which came out in October last year. There's a chapter on climate migration, and the book is called Human Rights Approaches to Climate Change. But for the presentation, I have updated it to include the Paris Agreement. To introduce this, in their very first report, the Intergovernmental Panel on Climate Change, in 1990 said the greatest single impact of climate change may be on human migration. And mind you, this was in 1990, right? And we are in 2016, and my question is, what have we done in this area? Of course, in the scholarly circles, there's a ton written on this. I mean, if you Google climate migration, I don't know how many hits you will get. But in the UNFCCC, things have moved very, very slowly. And there was a time when, this was not really talked about at all. It was like swept under the carpet, as they say. So there has been a mismatch between scholarly activities and policy action in this field. So that's why I'm very happy to see UNFCCC has included this in the Paris Agreement, not exactly the Paris Agreement, but in the decisions. But God only knows how long it will take for them to actually come up with some recommendations and stuff, right? So the other issue is, of course, as it was pointed out this morning as well, it's hard to find the exact numbers. Of course, we don't need the exact numbers. We know that it'll be in the millions. So, and the projections have ranged from 20 million to 200 million by 2050. So the numbers should sort of give us some pause, because we are not talking about a few hundred or even thousands. We are talking about a few million. So that means that we should do something about that, right? We can't just say, oh, the situation exists, and just forget about them. So I think at least the numbers should make us realize that something has to be done. And there's a lot of literature out there that, we already have climate migrants. The Stern report referred to them. So what are we doing about them, right? And then this is a form of adaptation. Although it's an extreme one, it's a form of adaptation, and people have migrated for various reasons. So should this be part of to me it makes sense that it should be part of the adaptation process under the climate change regime. But I do appreciate the fact that this is not confined to climate change. There are lots of reasons why people move and why people are forced to move. But I feel that if you try to include all of them, this might become unwieldy. With regard to climate migration, we already have a framework in place, so I feel that it might be easier to tackle them within that framework, but I do appreciate the point you made this morning in your keynote address, that we need to look at migration more holistically and not confine it to climate change. And then we come across this issue of terminology, right? What do we call these people? Right? How do we define them? Right? These two issues have been at the forefront of both writings and debate governing climate migration. Right? So we have used lots of different phrases, but what I want to point out is that none of them have any legal connotation. Right? We have not identified this category of people as a group that needs protection under international So we have forced climate migrants, climate displacees, climate refugees, but this, sorry, all these terms refer to people who are compelled to move as a result of climate-induced consequences, right? So whatever the consequence is, it relates back to climate change, and people are forced to move, whether it's due to conflicts associated with climate change consequences or due to lack of resources, whatever the consequence is, people are compelled to move, right? So there is a recognition even within the UNHCR that environmental factors may contribute to migration. And some, of course, on the flip side argue that people have migrated for centuries, so what's new, right? I'm pretty sure a lot of you have heard that as well. So Jane McAdam, who has written a lot in this area, recognizes that there will be movement associated with climate change, and it's clear that the current international and national frameworks are ill-equipped to deal with it. And that's an important point, because even now, we have a framework in place to deal with political refugees, but we have nothing to deal with climate migrants or climate displacers or whatever you want to call it, right? At the national level or at the international level, we don't have any frameworks, and what we have are not enough. They are ill-equipped to deal with this situation, right? So if you look at different types of migration, we have temporary, we have permanent, and we should have planned, and in some instances we do have planned relocation, mainly within states, within national borders, and each of these can be internal and cross-border as well, right? And to the extent that they are internal, international law doesn't technically come into the picture, but we are talking of situations where even with internal migration, the states concerned are ill-equipped to handle such numbers, right? We are talking about small island states. We are talking about least developed countries. Even internal migration of such numbers might be really hard for the states to handle. And on the other hand, something that didn't really come up this morning is the fact that their contribution to the problem is pretty minimal, right? We are talking of states whose contribution to climate change is negligible compared to developed countries, right? So here we are talking about a huge justice issue. These people are compelled to move, some are compelled to leave their countries, and the countries themselves are at the mercy of the international community because of something that they hardly contributed, right? So what is the responsibility of the international community? And what is the responsibility of Annex 1 countries, as they're called, developed countries? Because they cause the problem, they are the main culprits, if you like that word. And these small island states, low-lying countries, least developed countries have to cope up with a problem that they hardly contributed to, right? So what is the role of the common but differentiated responsibility principle, which forms part of the climate change regime? What is the role of climate justice or environmental justice? So I think it's important to highlight that when we talk about climate migration, because it's fine to talk about a legal framework, the fact that there's no legal framework at the international level to cover them, but at some point, even if we adopt a legal framework, we need to put an institutional framework to implement that. How are we going to do that? What is the responsibility of the international community to address that issue? I think it's important to address that. And even temporary migration, when we talk about or temporary displacement, can stretch into years, right? If we talk about, even these severe weather events, people are displaced sometimes for years. In these developing countries, because they simply cannot cope. The infrastructure is not there. So, temporary internal migration can be quite misleading when we look at specific situations. And then with regard to small island states, oh, really? I have about 30 more slides. With regard to small island states, at some point, people won't be able to live on those islands. So what are we going to do? People have come up with temporary fixes saying, oh, they can move internal, we can, maybe put them on stilts and things like that, but how long are we going to do that, right? Unless states are going to cut down their emissions. Already the World Bank has said that, if we go on as, if the projections go on as like we are doing right now, we are more likely to end up with a 3-degree or a 4-degree increase in temperature. And that's like the death sentence of small island states. So what are we doing if we don't cut down our emissions to 1.5? To even 2-degree increase would be a death sentence for them. So since I have only probably 2 minutes, the human rights at risk, I don't think I need to go through this list. Probably all the rights that we have been talking about are at risk if people are displaced, starting from right to dignity to right to culture, as you pointed out. And when it comes to small island states, there's even more at risk, right to a nationality, self-determination, right? If the state itself is going to disappear, what is the legal situation of the people of these countries, right? I think I'll skip all this. Defining climate migrants, there have been lots and lots of different approaches. Maybe I will just show my definition. This is in my book. This is the definition I came up with. Quite long, of course. I won't go through this, but basically to show that there is an obligation on the receiving state to accord basic human rights protection until such time they are able to return to their country, or in the event they cannot be, some arrangement has to be made in the receiving country. So there have been several proposals expanding existing law. We saw how infeasible, if that is a word, that's going to be, because the existing law has been adopted for a very specific reason. And then some have said adopting a protocol under UNFCCC might be better, adopting a protocol to the Geneva Convention, or a standalone treaty. A lot of people have said this is not going to work because there's not enough political support for that. And some have said using human rights law to govern climate refugees is the only plausible approach. But here again we run into an issue with regard to the basic sort of framework of human rights law, whose obligation it is, to whether it's the receiving state's obligation or the national state's obligation. And then, as I said, with regard to small island states, again, we run into this problem. If the state itself disappears, who is going to protect these people, right? So I think I'll stop there. Sorry if I ran over the time, but I have many more slides. I can share it with you if you want. Thank you so much.
Thank you. Next up we have Thekli and Anastasiou from the University of Sheffield, who's going to talk about migration as adaptation in the role of international
for being here, and thank you for the organization of the workshop. I'm Thekli. I'm going to talk about migration as adaptation. This is a work in progress, so feedback is welcome. And there's some overlap with previous presentations, so bear with me. I'll just go through it quickly. I'll start by giving some contextual elements. I'll keep that short. And then I'm going to talk about the shortcomings of international law as these derive from the relationship between migration and sovereignty, and how these impede the adoption or the acknowledgement of migration as an adaptation strategy. And I'm going to talk about the fragmentation of the law in this area, reactiveness, and securitization. So, for the purpose of my presentation, migration is a voluntary process. It has been traditionally been invoked as an adaptation strategy to deteriorating conditions, and displacement is an involuntary process which will most likely affect the most vulnerable population. Movement will most likely be internal, but the possibility of cross-border movement cannot be ignored anymore. And it's important to understand that the relationship between human movement and climate change is not straightforward. It is important to keep in mind that although we're using terms like environmental or climate change or migration and displacement, human mobility is a multi-causal phenomenon. So climate change and environmental disasters do not operate in a vacuum. They operate alongside socioeconomic conditions, political and demographic changes. So this infographic was created by the International Organization for Migration, and it illustrates quite nicely the relationship between climate change, migration, and displacement. So where there is a lack of adaptive capacity and comprehensive policy responses, coupled with deteriorating environmental conditions as well as socioeconomic conditions, displacement occurs because there's increased vulnerability. On the other hand, when migration is employed as a method to increase adaptation and to decrease vulnerability, displacement and crisis can sometimes be avoided. So migration is a helpful adaptation strategy because, first of all, the affected population can get out of harm's way, because communities and families can earn diverse incomes which are not dependent on the country of origin and how that country of origin is affected by climate change, through remittances, and because it provides relief on the affected community's resource stress. But it's my intention to show that although there is abundance of evidence and research indicating that migration can be a positive adaptation strategy, these has failed to be incorporated or be sufficiently acknowledged by international law. So I'll start with migration and sovereignty. This relationship shapes the characteristics of international law that I'm going to talk in a bit. So state sovereignty, as we all know, is a pillar upon which public international law is based. The traditional notion of state sovereignty implies control over territory and control over people. So the entry of non-nationals falls primarily within the domestic sphere. The only limitations to these are international obligations, and the most obvious one is the Refugee Convention. So it is not unlikely for the international community to provide protection or to create exceptions to their sovereign power to control border migration. But the issues I'm going to talk in a bit, fragmentation, reactiveness, and securitization, all derive from the unwillingness of states to surrender much of their sovereign power to control the entry of non-nationals. So the first very important characteristic of public international law in relation to migration is fragmentation. So there is currently no comprehensive body of international migration law. The current framework is built on norms and principles from different disciplines. The sources include human rights law, humanitarian law, international refugee law, international labor law, and there are many multilateral and bilateral agreements like the Pacific Access category, and soft law and guiding principles like the Cartagena Declaration or the guiding principles on internal displacement. Although increasingly a field of cooperation, fragmentation remains an issue affecting legal certainty and predictability. Preparedness, however, can be key in avoiding humanitarian crises and facilitating adaptation. There is little evidence of moving towards a more global approach to migration, despite the acknowledgement that international consultation and cooperation are essential for future plans of action. So the second important characteristic I'm going to talk about is reactiveness. Public international law is primarily a disaster-driven discipline. And what I mean by that is that international rules are often developed after particular disasters reveal and gap in the existing body of international laws. The International Refugee Convention was created on the aftermath of the Second World War. It was not a gradual process. The law did not develop through time and practice. It was a response to a particular disaster and a particular issue that disaster created. So in relationship to migration and environmental factors, the existing body of research and discussion within the international community focuses on climate change. So this is the international community's normal reaction to an issue perceived as urgent. What this discussion fails to take into account is natural environmental change and disasters that exist irrespective of anthropogenic intervention, and migration as a natural response to that environmental change. So climate change is indeed an exacerbating factor. It can increase the frequency and magnitude of disasters, that's not contested. But a holistic approach needs to consider migration as an adaptation process, and it needs to facilitate a more permanent solution to the issue rather than just mitigate climate change. So the Conference of Parties in Copenhagen and Cancun did indeed emphasize the need to consider adaptation methods alongside mitigation of climate change. In 2011, it was asserted that adaptation and mitigation should be considered on equal grounds. And although efforts have been made towards that direction, migration is yet to be acknowledged as part of that adaptation strategy, of the adaptation plans. So evidence of how migration is neglected can be found in the COP21, because there was talk about displacement, but there was no talk on migration or on migration as adaptation. The limited practice that exists, which addresses specifically human movement in in the context of environmental conditions, consists of provisions of temporary or humanitarian assistance post-disasters, like humanitarian visas or temporary protection schemes. So all these shows that there is a tendency to, on the part of international law, to consider post-disaster displacement as more important than adaptation strategies. And the last important characteristic I'm going to talk about is the securitization of migration and climate change. We've already talked a little bit about it. I'm going to talk about national security and the protection of state sovereignty and territorial integrity. So states view climate change as a threat multiplier, and that reinforces the view that climate change exacerbates existing conditions. However, migration is perceived as one of those threats that will be aggravated by climate change. So when in 2007 the Security Council discussed the impact of climate change on peace and security, the general contention was that the Security Council had to protect the integrity and security of states, and it was asserted that one of the obvious issues was migration. So migration in the meeting was associated with hatred and alienation, and it was asserted that migration can increase poverty and discontent, which will enable recruitment by rebels and terrorists. In 2008, the High Representative and the European Commission communicated that Europe must expect substantially increased migratory pressure, and that efforts should be made to avert that migratory pressure. In 2009, the United Nations General Assembly, although acknowledged the difficulty in making accurate predictions on the number of environmental migrants, it nevertheless reinforced the view that migration can increase international or internal conflict, tension, and violence. And whereas there have been attempts to shift attention towards human security, 7 years after the first Security Council meeting, during the Security Council's discussion on challenges for small island states, migration is still depicted as a destabilizing factor, and the Council is urged to tackle the root causes of illegal migration and states to battle transnational crime by enhancing border control. So basically we've got the securitization of climate change, which is associated with conflict and violence, and the securitization of migration, which is associated with terrorism, crime, and general instability. Because of the perception of these two processes as threats, migration has been reduced to being considered as an end result. It is understood to be a consequence of climate change. That leads to the false conclusion that if climate change is mitigated, cross-border migration will be reduced. But this fails to take into account a very important factor in every migratory process, and that's the human factor involved in the decision to migrate. The result of this process of securitization in general is that migration is largely considered to be a problem, and it fails to be considered as a possible solution to the issue of displacement. And it's failed to be acknowledged as a way to increase resilience, reduce vulnerability, and improve livelihood security. So the general conclusion is that the evidence and research that indicate that migration can be an effective adaptation strategy capable of reducing to an extent displacement has failed to translate into law. For migration to be advantageous, both for the countries of origin as well as migrants and host communities, it must be managed and controlled, and in the words of the Nansen Initiative, facilitated with dignity. And this can only happen by way of developing new pathways for legal migration. The current framework we've got is inconsistent and inefficient, and includes no explicit mention to migration in relation to climate change or environmental factors. And to cite the Lotus case in the Permanent Court of Justice, it was said that international law governs relationship between independent states, and the rules of law binding upon states emanate from their own free will. And my assertion is that this is still the case, and the creation of international law can be an expression of state sovereignty. States are much more willing to abide by a law that came to be after careful consideration and negotiation. So for migration to be facilitated in an orderly manner and with dignity, the international community needs to acknowledge the issue as one of universal reach and work towards a more harmonized and comprehensive approach, whether that is by way of regional or international instruments. Thank you all.